The next court hearing is from July 13th. This is not within the confines of the wrongful death case. The hearing we are going to now is from the criminal case, where there is still ongoing discovery fights regarding who can access Karen Reed's cell phone and whether she gets her cell phone back or not, and what discovery is being turned over.
The warrant doesn't exist in the abstract. It exists because the Commonwealth has advanced a theory, a stated theory on the record, that basically Karen Reed potentially engaged in some sort of witness intimidation. That's the foundation for what the Commonwealth has suggested precipitated the warrant in the first place. And it's on the strength of that, what we believe is a very flawed and a false theory. They went to a judge of the court and they said, we need a warrant naming her, Karen Reed, and they seized her phones. And today, in this moment, the special prosecutor is actively litigating to keep her phone away from her, out of her possession.
In the context of the case against Turtle Boy, Karen Reed was not indicted in that case. So while they might have had grounds for a search warrant at some point, we know that there's been ongoing issues with them trying to get back Karen Reed's property. If they are talking about the physical cell phones, why haven't they been returned? She's not been charged. If they extracted the phones, then why haven't you given back the physical phones? Which, depending on when these phones are from, those phones might actually be relevant to her defense in her civil cases.
Let's be clear about what the governing law is at the outset, because the entire Commonwealth's opposition depends on the court and in hopes of the court applying the wrong legal standard, which I'm sure it is not want to do. The right one is in place. When the right one is in place, the entire argument by the Commonwealth falters. The rule for prosecutorial disqualification, and I say that with an emphasis on the word prosecutorial because I'm going to get to a point that Mr. Cosgrove cites in his moving papers that is incorrect citation and incorrect application of the law.
Oh, boy.
The rule for prosecutorial disqualification in this Commonwealth is told to us by a couple of cases that we cited in our moving papers and the court has in front of it, Pisa and Ellis. And the words matter. No showing of prejudice is necessary by Ms. Reed at all. The court does not weigh whether actual harm resulted. It does not weigh whether actual prejudice exists. We don't have to show any of that. The law does not ask whether the conflicted party, in fact, changed any outcome. We don't have to show that. And Ellis completes that rule.
Cosgrove in this case is appointed as a special prosecutor. So the reason we are hearing him talk about the special prosecutor, I'm curious, but there was a special prosecutor in this case along with Reed too.
And Ellis completes that rule by saying that a prosecutor's discretionary choices have to be, and this is the important part of that language, completely and utterly unaffected by any private interest in fact or, and this is the big whopper, in appearance. It's those two words that I want to focus on for a quick second. In appearance. That phrase is the whole case. The law does not ask whether the special prosecutor, whether Mr. Cosgrove was actually influenced by Mr. Morrissey or anybody else in the Norfolk County District Attorney's Office. It asks very simply whether the public looking at this arrangement can have utter confidence that he was not in any way influenced by the DA's office. In other words, the law asks a very, very clean question, Judge Doolin, and the answer is very clearly as clean. It is no. The public cannot have that confidence. And I ask the court to just hold that law in the back of its mind for a second as I talk about the next point of the argument, which is the actual indication, the evidence of the breach of that promise. And this is because of the facts of the case. There is a breach because of the facts, and the facts are not very friendly to Mr. Cosgrove's position.
Okay.
And they're also not in dispute because they came right out of the special prosecutor's mouth. On February 19th, from the podium,
What year?
Attorney Cosgrove told the court that he would basically sit down with the district attorney's office. He was going to go through all of their options. They would weigh the pros and cons of all their options and discuss those pros and cons, and then get back to the court in due course.
What?
His actual language is this, and I'll quote him. Quote, "I'd like to take some time to look at Judge Krupp's decision."
If the special prosecutor was appointed because of a conflict, then there is a wall between them and the DA's office. If the special prosecutor was appointed because they didn't have enough resources, it's different. But if the special prosecutor was appointed because of a conflict, then they can't sit down with anyone at the DA's office.
And to meet with the district attorney's office, the Norfolk County District Attorney's Office, I intend to do that within a week or so and discuss with them our various options. And we are going to give, are we going to give the cell phone back? Are we going to move for reconsideration? Are we going to file a notice of appeal? And when
At the beginning of this, Alan Jackson led with that Cosgrove was arguing that the conflict was as to Aidan Kearney, not to Karen Reed. So is the prosecution or the special prosecutor trying to say that sitting down with the DA's office was not improper because they were talking about Reed's subpoena? However, it would seem to me, if this is the witness intimidation case, that the witnesses that are alleged to have been intimidated are the same witnesses on the Karen Reed case, so that line becomes very blurred because the conflict is really going to the witnesses in the middle of it, not as to the defendants in the case.
those personal pronouns and the possessive pronouns used in that phraseology, in that paragraph, are not of insignificance. Who is the we? Who is our options? Who's the our in those sentences? Obviously, it's in perfect context. It's Mr. Cosgrove, and it's the Norfolk District Attorney's Office. In an unscripted and what I would consider to be a pretty unguarded moment, Mr. Cosgrove betrayed exactly what's going on here and who's really prosecuting this case. And I put prosecuting in quotation marks, but who's advancing or forwarding this case against in terms of the search warrant against Miss Reed. He isn't investigating Miss Reed. They are investigating Miss Reed. He isn't holding her phone. They are holding her phone. And he said the quiet part out loud. They're improperly holding the phone together because they're coordinating together. And those are his words, not my words. He could not and was unwilling to independently make any decision in front of the court what to do about Judge Krupp's very unequivocal order to return Miss Reed's phone.
That's not good.
Unless and until he met with the district attorney's office. This is with the completely walled off Norfolk District Attorney's Office, the conflicted office, the office headed by an alleged, a self-described victim of Miss Reed, Mr. Michael Morrissey. He was the authority. Mr. Cosgrove admitted he needed.
There's the conflict. If you're the special prosecutor because of conflict, you can't talk to anyone at the prosecutor's office. That's the point, is that you can't talk to them.
So Mr. Cosgrove, in his moving papers, he sees the problem, obviously. He's a very intelligent gentleman, a very good lawyer. He sees the problem in the accidental admission, and so he tries for an escape route. His claim now is, no, I was just notifying, I was indicating that I would notify the DA's office about what I intended to do. Except, Judge, that's not what he said. He said, I can't decide until I meet with him and
can't
we
decide,
discuss
not the same thing.
Our various options. That doesn't sound like informing anybody of anything. Certainly doesn't sound like informing anybody of a decision that's already been made. I think the court would agree with that. Rather, it sounds like a conversation inviting everybody to weigh in. Everybody is invited to the table.
The judge is The judge's face is facing. The judge is like, what the fuck? I have the same, what the fuck?
Everybody is invited to the table. Let's talk about strategy. Then, Judge, I'll get back to you. Mr. Cosgrove actually showed us what's really going on behind the closed doors that we suspected all along. So who's really
in charge
advancing this case?
What are you looking to disqualify Mr. Cosgrove from? Any involvement in the Reed cell phone issue?
Yes.
Or also, you shouldn't, do you believe that you have standing in the case of Commonwealth versus Aidan Kearney?
I don't think he can ask to disqualify him off of the Kearney case, but he can ask him to be disqualified off of any further argument regarding Karen Reed's cell phone.
So that's a very good question, and I wrote in my notes. The judge is going to ask you, what do you want me to disqualify from?
That was pretty good.
That is the question. It really is, Judge. Yes. In answer to your question pointedly,
From the cell phone.
He should not, Mr. Cosgrove, and like I said, seems like a kind gentleman, very good lawyer, but he cannot advance the case having anything to do with Karen Reed. Why? Because the investigation, as it is, for whatever that investigation is, the only insight I have, the only crystal ball I can rub, has something to do with this search warrant. So He should have nothing to do with advancing the search warrant. He should be removed altogether because the DA's office is removed altogether. And if, in fact, to answer the
Right, the DA's office is removed. He is now essentially tainted by having these intermingled conversations with the DA's office, which creates a further conflict as to Karen Reed.
The next question the court might have, if in fact there's another special prosecutor that were to be assigned to this case, God forbid, to complicate matters more, that person should have no communication, no contact with Mr. Cosgrove, nor the Norfolk County District Attorney's Office.
And who should appoint that person?
That's the $64,000 question, Judge.
We'll make the court do it, because generally special prosecutors are appointed by the district attorney's office.
I don't believe that person can be appointed. I believe that this has run its course and that the district attorney's office was supposed to do what it wished to do by hiring an independent special prosecutor. Unfortunately, that independence was magnificently breached, not in a small way, in a big way, in the biggest of ways. And so I think the district attorney's office is not in a position to say, okay, well, I'll do it again. I'll take a mulligan on the first one, and I'll do it again and appoint a second special prosecutor. That search warrant should be dead on arrival because Judge Krupp said the phone has to be returned.
Okay, let me call upon Mr. Cosgrove.
Of course.
Yeah, Mr. Cosgrove, go right ahead, sir.
Oh, boy. Let's hear what Mr. Cosgrove has to say.
Well, Your Honor, let me begin where Mr. Jackson began with the discussion of standing. And Mr. Jackson made a wonderful argument that his client had standing to litigate the possession of her telephone. He made a terrific argument that she has standing to challenge the search warrant, but I heard no argument as to what standing she has to raise the alleged conflict of independent counsel, because there is no conflict. Obviously, as I pointed out before, the district attorney just went through 2 trials with Ms. Reed. They were not conducted by a special prosecutor, with the one exception of the special prosecutor for the second trial, Mr. Brennan.
Did you just say they were not tried with the special prosecutor with the exception of the special prosecutor? Are those the words that just happened? Is he trying to say that the special prosecutor was not because of a conflict? Like it wasn't conflict counsel? Because I don't know why Brennan was appointed. I don't know if Brennan was appointed because of a conflict or if Brennan was appointed because the rest of the DA's office was like, fuck this, I'm not going to trial again.
With the one exception of the special prosecutor for the second trial, Mr. Brennan, who worked hand in glove with the personnel from the DA's office. So it seems to me, Your Honor,
I think he's trying to make the argument that there was no conflict. I don't think you can argue that because a special prosecutor in the Reed case wasn't there because of a conflict, that means that in this case it's the same. I don't think that tracks.
That Ms. Reed has no standing because there is no conflict. Even if I were consulting with the DA's office on my every move, which I am not, I don't see that there would be a problem.
Okay.
I have yet to hear what Mr. Morrissey's personal interest or conflict is in this case. It was represented in the papers that were filed that he was a victim. And I heard Mr. Jackson describe him as a self-described victim. I don't know when or where or if he actually made that statement or what the context was, but certainly there has been no indictment that I am aware of or charge or whatever listing Mr. Morrissey as a victim in any way of this case. As I listen to Mr. Jackson recharacterize my comments, I can't make that decision. I can't decide that. They do seem quite damning. The only problem is those aren't the comments that I made. I made the comments
Okay, what
that
did
I
you
made.
say?
They're a matter of record. They were quoted in the initial filing. They were quoted
What
in
are
my
they?
filing.
So what did you
Submitted
say?
an affidavit explaining what actually happened. Credibility of that affidavit is, of course, for Your Honor, and I'm not going to argue it. If Your Honor finds that I have an ethical conflict of interest and can't serve in this case, I think that counsel for Mr. Kearney will be in court tomorrow morning,
Yep.
waiving your decision.
That's probably
saying
true.
the Commonwealth has had a full and fair chance to argue the situation, and it should be applied res judicata. So I think that's going to be the bottom line. Finally, Your Honor, I'd like to comment on the credibility of the other side in this case.
No, why?
My attention was
Why?
recently given to a video recording of the March 18th, 2025 second trial of Karen Reed. And I observed the video
Why?
on the internet. Therein, a justice of this court made the following oral findings, and I'm going to quote them.
What are we doing? I bet I can guess what's coming next. Where the judge was very upset with counsel for misrepresenting things to the court.
In open court, Judge Kearney said, based on all the evidence, I conclude that the candor required by all lawyers has not been demonstrated here. I find there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate. They were made in sidebar, in open court, and in pleadings. And after going through some of the details, she says, I find that there was a material misrepresentation and that it was.
Did you put this in your pleadings, or are you just trying to spring it up here? Because the judge is like, what the fuck are we doing?
Deliberate. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. Those comments were made with respect
Counsel?
to Mr. Jackson and the colleagues from his firm
And?
who filed the motion and affidavit and did the oral argument before the court today. I would ask the court to consider that finding with respect to the credibility of the defense finding.
Wow.
And I will close with
Did you
the words
submit
of
the
Mr.
transcript?
Jackson. When someone shows you who they are, believe them the first time.
Okay, counsel. Did you put that in any of your motions? Because that kind of goes beyond argument if it's not in your motions?
I find it rich that a member of the bar who doesn't like what his own facts represent decides to take a personal shot at opposing counsel. I think that's beneath Mr. Cosgrove's dignity. It's certainly beneath the court's dignity. The court doesn't have any idea, because it wasn't sitting in the courtroom along with Judge Kearney, what the circumstances of those comments were.
There's been no transcript submitted. If this was of such grave concern to Cosgrove, pull the transcripts and submit them.
Certainly, Mr. Cosgrove has absolutely equally no idea what those comments were, and it's offensive, but it also is very telling. It's extraordinarily transparent.
Your Honor, when you can't attack the facts, right?
If you don't have the facts on your side, then you argue the law. If you don't have the law on your side, then you argue the facts. And if you don't have the law on your side or the facts on your side, just attack opposing counsel.
I thought you were supposed to bang the table.
I think so.
Right. You're supposed to bang the podium.
I thought you were supposed to bang the table.
I think so. Exactly. That was try to make it as loud as you can.
Bang the podium.
That was the old saying, anyway.
Yes, exactly. And I think everybody in the courtroom can see that. It's a little bit of an act of desperation. And I appreciate the cleverness and the desperation that Mr. Cosgrove shows, but it is no legal moment for why we're here today. So no, to answer the court, once again, I am not suggesting I take no position on Mr. Cosgrove's further investigation or prosecution as it relates to Aidan Kearney. That is not my position. He is not my client.
The judge is just like, right, we know what this is.
But what I am concerned with is his position in terms of the search warrant and any further investigation into Karen Reed. I'm going to step up a little bit from the personal attacks and invectives. I don't think they're appropriate in the courtroom, and I'm not going to lower myself to engaging in those. The court doesn't have to find, at the end of the day, that there was actual prejudice or that there is actual prejudice against Ms. Reed or her interests. The court does not have to find that there's actual bad faith on the part of Mr. Cosgrove. Neither does the court, or neither does.
However, the arguments he was making in court are kind of giving bad faith, aren't they? But Jackson has turned it back around to, I am not stooping to this level. I'm not going to roll around in the mud with this. I'm going to remind the court that the standard the court needs to consider is this. And so he's bringing it back to the legal argument while saying, this is beneath me.
Neither does the court, or neither does the law, require that the court find that anyone lied or anybody was mendacious. I'm not suggesting that. And the court doesn't have to find it. Or that he, in fact, made any decision that was on its face corrupt or conflicted. The court doesn't have to find any of that. The law is very clear, Judge, and that's why we're standing before you. It requires one thing. It requires independence in fact and in appearance, and that has been breached. The only remedy as it pertains to Ms. Reed's interests is to disqualify him from any further contact or connection with the search warrant and any investigation related to witness intimidation.
Okay.
Thank you.
Thank you very much. Thank you all for being here. I'll take it under advisement.
Thank you, Your Honor.
Thank you.
Appreciate the time.
Thank you, Your Honor.
We took a look at the July 13th, 2026 hearing regarding the search warrant for Karen Reed's cell phones, the fact that another judge has ordered Karen Reed be given back her cell phones, that the cell phones haven't been given back. And now the argument from attorney Alan Jackson is that the special prosecutor, he is arguing, was appointed because of conflict at the Norfolk District Attorney's Office with this witness intimidation case, that the special prosecutor, as to Karen Reed's cell phone, the search warrants and all of that, should no longer be the one handling anything to do with Karen Reed's phone, the search warrant, etc., because that special prosecutor has, as Jackson argues it, by his own words, said that he is having communication and going a step further than having communication with the Norfolk District Attorney's Office, but saying, I can't make those decisions on my own. I need to run it by the Norfolk District Attorney's Office, which means then they are not, in fact, an independent special prosecutor. And the special prosecutor argued, one, don't believe what Alan Jackson said because this is what Judge Kearney said about him or the Reed defense attorneys. Two, even if there was a conflict, and I'm not saying that there is, it's not as to Karen Reed because this prosecution is to Aidan Kearney. And three, I'm allowed to talk to the Norfolk DA's office. And four, I'm not asking them for their blessing on what I do. Surely I am not always asking them what I should do. He did not say he is completely independent and he's never spoken to them. So I'm going to need to do a little bit more of a deep dive into WTF is going on with this, because I remember when we heard from Judge Kearney, who said there's no reason to continue to hold Karen Reed's property as to Karen Reed's criminal case with Judge Kearney. But then we also hear that the judge in the Turtle Boy witness intimidation case also said you have to give her back her phones. So they're not being held because of her criminal prosecution, which is done. She was acquitted. And they're not being held as to the investigation into the witness intimidation because she was never indicted, even though they asked for that and they didn't get one. And that investigation as to her is over. So on both criminal cases, her property's been ordered returned. So give it back. And I wonder what's going to happen with either disqualifying Cosgrove if they are continuing to fight not giving the phones back. Which begs the question, why are there still fights over this? Why are they still fighting this? Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.